Good evening. This is the December 17th meeting of the Lincoln City Planning Commission. Please join me for the Pledge of Allegiance. Thank you. James, could we have a roll call?
Lenny Nelson.
Here.
Patty Crowan.
Here.
Miles Schlesinger.
Here.
Marie McFarland. Joshua Brainerd.
Here.
Marcy Baker.
Here.
Steve Griffiths.
Here.
Okay. Anne Marie, any agenda changes or revisions?
None tonight, Chair.
Okay. We have the minutes from our December 3rd regular meeting. It's in the packet. I just have a couple of comments on it, James. And we chatted about this a little bit. On the bottom of page 6, the very last word, it starts a section that appears to be your notes. So you might want to go through and clean that up a little bit, if you would. And also the spelling of chiefs, and I don't know, CHIEGS might be a word because it didn't pop up on your spell check, I guess. So, any other comments or concerns about the meeting minutes?
I move to approve with those corrections.
Okay.
Second.
All in favor?
Aye.
Any opposed? Okay, that's done. Final orders, resolutions, and written communications. We have a final order for the recommendation of ZOA 2019-13 tradition. I'll get it. Transitional housing. We need a motion for finalizing this? Hi. Do we need a motion to finalize? Yeah, okay. Do I have a motion to finalize the recommendation for transitional housing?
Move to finalize.
All right, do I have a second?
Second.
All in favor?
Aye.
Any opposed? All right. And then we have the final order for the conditional use permit 2019-04 for transitional housing. Do I have a motion? Anyone?
Move to accept the final order.
Thank you, Lenny.
Yeah, anytime.
And a second?
Seconded.
All right, all in favor?
Aye.
Aye.
Any opposed? Okay. All righty. Actually, I need to back up a second
Okay.
because I have a comment on this. I'm looking at the amendment to Title 17 zoning, the recommendation to the City Council. And in the final recommendation, there's a statement in it that is not correct.
Okay.
It says that the Planning Commission recommended on a 7-0 vote that the City Council approve the draft ordinance, excuse me, and then it follows with the additional recommendation of adding transitional housing as a conditional use in other zones besides commercial, general commercial. That's not accurate. We did not recommend that it be added. We recommended that the City Council talk about it and think about it.
Discuss it. Okay.
So that needs to be fixed because we did not make that recommendation.
It's true.
So you voted on approving this,
I know, I
or
missed
is this
that.
going to be unanimous consent to correct it, to say consider instead of adding?
I move to,
Well, unanimous consent would just be the chair says, let's correct this to say
Let's correct this.
we're considering, to consider adding transitional housing, but
Okay. Well, I mean, we didn't even, it wasn't noticed for all the zones.
Yeah.
It was just noticed for general commercial, so this wouldn't be even legal.
So what you're really saying is you didn't feel like you had the authority to do it now, but you wanted them to look at it in the future, so.
Yeah,
So consider in the future.
right.
Because transitional housing wasn't listed as conditional under any zones, that they should maybe consider.
Right, we just want them to talk
because
about
we
it.
just- Yeah, exactly.
Yeah.
So with that's unanimous consent, if nobody objects, that will make that change and the
Okay.
chair will sign it.
Does anybody object to that? Okay, done.
Mr.
Sorry.
Apichello, is that something that we can handwrite in, that language?
Yeah, or you can send me the word. Actually, I'll try to get it off the minute track here and see.
Okay.
Okay. Sorry about that, jumping the gun there. Okay, now we are to ZC? Yes. So it is now 6:07 PM. The public hearing for file CPA and ZC 2019-04 is now open. This public hearing concerns a request to amend the comprehensive plan map and zoning map to change the property addressed at 2126 Northeast Quay Place to a comprehensive plan designation of General Commercial District, GC, and zoning of General Commercial, GC. The site contains one structure. The applicant is John Sutton, and the property owner is Catherine Sutton. The commission must take a few moments here to cover some preliminary matters and required statements. Does any member of the commission wish to declare an ex parte conflict, contact, conflict of interest, or bias in this matter? Did anybody drive by the property?
I drove by the property.
Pardon me?
I did.
Okay, you need to declare that.
I drove by the property, can't see it for the trees.
I have, about a year ago, toured the property because it was advertised as for rent, for commercial. So I'm familiar with the inside.
Okay,
So that what you're required to do for site visits are the same as ex parte communications for purposes of disclosure. Disclose the substance of what you observed. Lenny apparently saw trees,
I saw trees.
and you saw the interior of the building.
Yeah, I toured the inside and saw the back.
And you need to affirmatively state that there's nothing about that observation that prejudices you, and you will make a decision based upon the application of the facts in the record to the applicable law.
Right, yep.
You agree?
Nothing
What-
about seeing it bias my opinion on.
What he said.
All right.
okay. Does any member of the audience wish to challenge the qualifications of a commissioner to participate in this matter? Okay. The following statements are required to be made at the commencement of the hearing pursuant to the City Code and ORS 197.763, Section 5. Staff will now read a list of the applicable substantive criteria for this decision.
Thank you, Chair. The subsystem criteria for this decision involve 3 different items: the Oregon statewide planning goals, the Lincoln City Comprehensive Plan, and applicable provisions of the Lincoln City Municipal Code Title 17.
Okay. All testimony, arguments, and evidence must be directed toward those 3 applicable substantive criteria, or such other criteria in the plan or land use regulations which the person believes applies to the decision. Failure to raise an issue accompanied by statements or evidence sufficient to afford the decision maker and the parties an opportunity to respond to the issue precludes appeal to the Land Use Board of Appeals on that issue. Failure of the applicant to raise constitutional or other issues related to proposed conditions of approval with sufficient specificity to allow the decision maker to respond to the issue precludes any action for damages in circuit court. Prior to the end of this hearing, any person who participated may request a continuance to provide additional testimony, argument, or evidence, or request that the record be left open to submit additional written testimony, argument, or evidence. Before the staff presents a report, I would like to summarize the public hearing procedures which have been adopted by the Planning Commission and the City Council. A summary of the public hearing procedures is on the table by the entrance to the council chambers. Generally, the order of proceedings will be as follows. These preliminary matters and required statements, followed by a staff report. Then the Planning Commission has an opportunity to question the staff, the applicant's presentation, and then those of you who are in favor of the application, those who are neutral, and those who are opposed. Then we'll take testimony from public agencies, a rebuttal by the applicant if they've set aside some time for that, requests of continuances or to leave the record open, close of the hearing, close of the record, requests to submit written arguments, deliberation, and decision. The city has established some time limits. The applicant will have 15 minutes and may reserve up to 5 minutes of that time for rebuttal. After the applicant testifies, any person may speak for up to 3 minutes. If the Planning Commission has questions for you, your time spent responding to those questions won't be counted in your time limit. If you wish to speak, please print your name and mailing address clearly on the sign-up sheets on the table at the entrance. When you come up, we'll ask you to speak into the microphone and begin by stating just your name. If you have any written testimony or information you want to provide, you can give that to James. Okay, staff, please present your report. Thanks.
Thank you, Commissioners. My name is Anne Marie Skinner. I am with the Planning and Community Development Department. As has been stated, this is case file CPA-ZC 2019-04. And staff has identified this as the Sutton Comprehensive Plan Amendment and Zone Change Request. Applicant is John Sutton. The property owner is Catherine Sutton. The site is addressed as 2126 Northeast Quay Place, and it is located on the east side of Northeast Quay Place, approximately, and that is the property right there, if you follow the cursor. That's approximately 230 feet north of the Northeast Quay Place, Northeast 21st Street intersection. The current comprehensive plan designation for the site is high-density residential, and the current zoning district for the site is multiple family residential, and the site is 6,970 square feet. The applicant proposes a comprehensive plan map amendment from RM to GC and a zone change from multiple family residential to general commercial.
Is the brown shown on the map the zoning?
Yes.
Okay.
The site itself
Right.
is zoned RM, which is multiple family residential. Surrounding uses and zones are as follows. As you can see from the map, immediately adjacent on all sides, the site is surrounded by the multiple family residential zoning. To the north, at the corner of Northeast 22nd and Northeast Quay Place, there are 2 parcels that are zoned general commercial. Across the street from Northeast Quay Place, that is zoned park, and that is used as the community center for Lincoln City.
You have a question, Steve?
Other than the church that's in that block right there, are there any other uses other than residential?
I am not aware of any other than the church. The applicable required notifications took place by the Planning and Community Development Department staff, including notice to the owners of properties within 250 feet of the site and publication of the public hearing in the News Guard. As stated previously, the amendment must be in conformance with the Oregon statewide planning goals, the Lincoln City Comprehensive Plan, and the applicable provisions of Title 17 of the city's municipal code. This application was received October 21st, 2019. The site contains an existing structure and mature landscaping. Records from the assessor's office indicate that the structure was built in 1962. The applicant states that the site was previously owned by an attorney named William A. Pusey, and that attorney constructed that building in 1962 and utilized it as his law office until his death. Upon his death, his estate was dismantled. That was in February 2018. The applicant did provide in the materials that were submitted as part of the application records from the county assessor showing the commercial improvement appraisal card with the statement, based on current records and this appraisal card dated 2/87, this property has been appraised as commercial improvement on residential land since 2/2/87. Under the site's current zoning of multiple family residential, office use is not permitted. It's not permitted outright, and it's not permitted conditionally. The use as the law office, since it began prior to the zoning designation, was allowed to continue as a non-conforming use. The non-conforming use, pursuant to the city's code, may continue as long as it remains, provided the non-conforming use does not cease for any reason for a period of more than 6 months. So use of the site as a law office ceased more than 6 months prior to the date of the application. The application was October 21st, 2019, and use of the law office ceased February 22nd, 2018. Therefore, the non-conforming status ceased. The site may be used as one of the permitted or conditional uses in the RM zone, but to use the site as an office or any other commercial use, a successful zone change is required. The city's comprehensive plan provides for both major and minor revisions. The definition of a minor revision is listed as changes to the comprehensive plan and zoning map which focus on specific individual properties and which do not have a significant effect beyond the immediate area of the change. Staff considers this a minor revision since the requested change is on the property owners and the applicant's specific individual property. The Planning Commission does need to be aware that the application's statements regarding the intended uses are not binding unless a development agreement is approved by the City Council. Accordingly, if rezoned, the owner may use the property for any of the uses listed in the general commercial zone.
Anne Marie,
Yes.
did I miss something in the review of this? Is there a statement of what the plan is for this building? What the applicant?
Office.
Thank you.
The staff report lists all of the uses that are allowed in the general commercial zone. I am not going to go through all of those verbally unless the commission would like me to, because there are a number of them. The analysis then goes on to give a breakdown of all of the Lincoln City Comprehensive Plan goals and the statewide plan goals. Again, I am not going to read all of those because that That would take a little bit of time. And after the goals are analyzed, then the criteria is given for the general commercial zone. The general commercial zone does not have a minimum lot size. It doesn't have any minimum requirements for lot width or depth, and it has no minimum setbacks unless it's abutting or across the street from a parcel in a residential zone, which in this case it would be. So in this case, the setbacks on the north, south, and east would be a minimum side and rear setback of 10 feet. The applicant's materials did not provide information regarding the distance of the structure from the north, south, and east property lines. So staff was unable to ascertain if the rezone to general commercial would create a nonconformity in setbacks. Section 17.88.040 of Lincoln City Municipal Code Title 17 states that the Planning Commission shall study the request for the rezoning as necessary, including the holding of a public hearing, and recommend the approval or disapproval of the amendment. Staff recommends that the Planning Commission hold the public hearing on the proposed comprehensive plan amendment and zone change, close the public hearing, deliberate, and make a recommendation to City Council to either approve or deny the request based upon the evidence presented and compliance with the applicable criteria. Staff would also like to note something that was not included in the written staff report, because this question has come up in previous cases. The term spot zoning is not used any longer by the state of Oregon, legal or illegal, and the proper term would be from our comprehensive plan language, specifically on page 15 of the comprehensive plan. The amendment would need to be consistent and compatible with other unamended portions of the comprehensive plan.
Could you translate
Yeah.
Basically, a commercial zone in the middle of a multiple residential family zone would not be consistent and compatible with the other unamended portions of the comprehensive plan, because the unamended portion is the multiple family residential zone. And for it to be compatible with that, the multiple family residential zone would have to be amended to general commercial. Did I?
No, that's accurate. Basically, spot zoning hasn't really been used too much since 1975 because of the way that Oregon land use laws have kind of occupied the field. And the most important thing is that your proposals to amend your plan and your zoning are internally consistent with your comprehensive plan. I've said many times, amendments need to be internally consistent as well as consistent with the goals, the statewide planning goals. So when we look at internal consistency of a proposed change, you look at the text of the comprehensive plan and you also look at the map. If it's a spot of commercial in the center of residential, you could fairly conclude that that's not consistent with the existing unamended portions. A better approach might be to rezone a whole area and make it all consistent or internally consistent. So that's all Anne Marie was saying.
Madam Chair, does this mean we can't do that, or it's just not a great idea?
What you're required to find per your comprehensive plan is that the amendment is consistent with the unamended portions of your plan. So I'd say bad idea.
Madam Chair,
Yes.
could we just do part of that? Would we have to do all of the black and brown area?
No, well, that application is not before you.
Well, I know, but neither is the application to change all the other ones, so I don't understand.
Yeah, the application that's before you is a quasi-judicial application by one property owner to change one piece of property in a block. That's what's before you.
That's what we're making the decision on.
Well, yeah, but I don't understand if that's not something we should be doing. Why are we having this hearing?
Because we're required to have a hearing in response to a private application.
Oh, okay, that's interesting.
Other questions for staff? No, not right now. So just so I'm clear, so if this were approved, that building that's on the site could be leveled, and anything could be built on it that's consistent with the requirements or the uses in in general commercial.
Correct.
Other questions for staff?
As was stated, there was no development agreement, statutory development agreement, or otherwise submitted to bind the property owner to any particular use, so all uses in general commercial are on the table.
Right. All right. Any other questions for staff? Okay. Thank you, Anne Marie. The applicant's presentation. Is the applicant here? Yes, great.
My name is John Sutton. I'm the applicant, and my daughter purchased this property about a year and a half ago, and I came to the planning department to ask what uses I could do and what changes I needed to do to keep it as a commercial rental, and I was informed that all I had to do was just keep it an as is occupant. So if I had an attorney or a therapist in there, that would be fine. I wouldn't have to change anything. And so I remodeled the building. Took about a year to remodel it. And I had a tenant lined up, and I got back to the same planning gal, and she said, well, that's fine, but there's a statute that says it hadn't been occupied for 6 months, so it's a non-conforming use, so we can't help you out there. You can't rent it out as is. After I was told that from the same gal that, yeah, all I had to do was rent it to a like-kind business. So it was an investment for my daughter, and I put a lot of work into it, and she put all her life savings into it, and we're at this crossroads now where I'm trying to get it rented out just to get some money for my daughter's education, and was turned down. And I came back to the gal and said, what's the deal? She said, oh, well, I don't remember the conversation, but that's what it was. I wasn't able to rent it out to anybody, so it sits.
So the building itself was originally...
Could you introduce yourself,
Sorry.
please?
My name is Roberta Tryon, and I wrote the application for him. The building was originally built by Mr. Pusey. He was an attorney at law, and he used that building from 1962 forward as an existing law office. It has always been a non-conforming use in that space as an office. When Mr. Sutton bought it, he bought it as an investment to continue to use it as an office with no changes whatsoever. The building, because Mr. Pusey had been very ill for a long time, was in ill repair. It took more energy to bring the building up to a usable standard than he anticipated. He did not know during this process that he had to have his repairs done within 6 months, and he had to have it rented, or he would lose his zoning. And that's what happened. His repairs, unknowing to him that he only had 6 months to renovate the building, he didn't know that. It took longer. When he went in with the renter, he was denied the use of the permit. So we went into the city and spoke with the city, and they preferred that we go through a formal process and have this zone properly and not let it just stand in a non-conforming use, which I completely and totally understand. But the negligence of the city not to be able to have informed him that he only had 6 months, we wouldn't be here if he would have been informed that he only had 6 months time frame to keep it rented. And he's also paid $5,000 for the ability to sit here in front of you and ask you again to keep it zoned as it has been since 1962. If there was something in place within our city that said there was a misunderstanding, or there wasn't information that was construed properly, or it was misconstrued, or that it was just completely not available and wasn't part of that conversation, then there would be something there that could help rectify this. But because there are no, it's just black and white, we're in a situation where he bought a building, took his daughter's life savings as an investment for her, did not know he only had 6 months to have it rented, and lost his zoning permit. It has always been a law office. He has not changed it in any shape or form. He has not changed the outside of the building or the inside of the building. It is what it is, what it has always been for 62 years, and we're now having to reapply for that zoning. Next to it is a church that is in a residential area. What is the name of that church? The type?
Church of
It's
Christ.
changed now, so.
I think it's a
It's a
Church of Christ.
Church of Christ. So it has been there for numerous years as well, sitting in the middle of a residential area, and this sat beside it. And it sits directly across the street from the community center. So there is commercial on the end of the street. Mr. Oxenholt has bought that and redeveloped it. This just was never zoned as commercial. It had conditional use on it since 1962. We're not asking to change the building or tear it down. We'd be happy to put a deed restriction in that says once he was finished with the building, it would revert back to residential if necessary. But the building is not specifically constructed to be anything other than what it is. And to refit that building to make it into something that would be residential would cost hundreds of thousands of dollars. So basically what this is an error that happened between a citizen, public citizen, and the planning department. Information wasn't construed to him that he only had 6 months, or he would have stayed within his guidelines and nothing would have happened. That is what it is. We're not asking you to, I mean, it's a tragic situation, but the building has also been in existence since 1962 as an office, a law office.
When you came into the planning department the second time and were told that you would have to get it rezoned, was the idea of a development agreement proposed to you in any way?
No, not at that point.
Steve?
When you purchased the property, did your real estate agent inform you the office was a non-conforming use? And you only had 6 months to
I'm
turn
his
it
real
into a
estate
new office?
agent.
Huh?
I am his real estate agent, and the property was never conveyed to me that he only had 6 months either.
So in the title search or anything, nothing
Title search
came up
does not say that.
with anything?
It had a mixed use. It had a residential zoning with an overlay of a commercial use. And originally, when we looked at the building, we wanted to actually switch it to residential if it was possible. And we went into the city planning with that idea, and they said the retrofit on that would be just astronomical in that area. And he didn't want to change it into residential to begin with. He wanted to keep it as commercial. And they told him emphatically that if indeed he left it as it was, made no major changes, and rented it, he could continue to use it that way. What was missing was the 6 months part.
Other questions, Marcy?
I have a question. You mentioned you had a tenant lined up. What type of business were they intending on using there?
It was a home health care business.
It was an office.
Other questions?
Madam Chair.
Yes,
Never mind. Change my mind.
I think it is in best interest for the council that
the commission,
The
we're not the
commission
city
here.
council.
we have never seen anywhere unearthed the 6th month in writing.
I believe it's in the zoning, isn't it? Isn't it?
It's in Title 17.
It's in Title 17, and if you're going to sell property in Lincoln City, it'd probably be wise to become more familiar with that.
I've sold property here for 18 years,
And
and
you
I've
never
never
looked at
run,
the zoning code?
and I've never run into this situation. And he was in the city planning numerous times before he bought the property, asking numerous questions from everyone, what was necessary, what needed to be done, how he should proceed, if the building had any issues. And it did have it had an issue. It had an oil tank in the back of the property that had to be issued out with the DEQ situation, and everything was taken care of. What happened is that he took longer to remodel it than he anticipated.
What date did you
It's your mic, please.
what date did you buy the property and come into the planning commission?
It was March of 2018, and I came in prior to that, and I talked with the planner and the building apartment fella, Brandon. He said I don't have to change anything as long as I rent it out to a like-kind business. So
If he died, though, in 2018, the 6 months would have been expired before you even purchased the building.
right. But I was not informed of the 6 months, nor did I read Article 17.
Or was he given Article 17 to read?
Excuse me?
He wasn't, he also was not given the material that he needed to be able to read regarding
This is
the
a,
property he was purchasing.
Chair, this is a rezoning application, so we might want to actually proceed with testimony regarding rezoning the property.
Well, I think part of the issue here, though, is that in rezoning something, we are attempting to do what is correct with the city. And I think in the long run, even if this issue hadn't come up, it would still be in the city's best interest if this was just zoned outright what it is, instead of having a multiple layer of residential with an overlay of commercial on top of it. So
Well,
I
that's
don't,
not what it has. It's
That's what it
it's
did have.
residential.
No.
but that is what it had when he purchased it. It was a very,
It didn't have an overlay zoning on it.
it had a outright usage of commercial in a residential zone. It had been a law office, and that's what it was.
But that's a prior non-conforming use, that's not outright use.
And
Okay,
that's what I'm
different.
saying. But also, what is the church next door to it?
That's a permitted use in a residential zone. A church is.
Conditional use.
It's
Churches.
conditional.
Yeah,
Okay.
it's a-
Conditional
So a
use.
church is not considered commercial in any way.
No.
It's just a church.
right.
But it still is not residential.
But it's a permitted use.
Conditional use.
It's a conditional use.
Conditional.
So if the issue was to be that the city would prefer that it be residential, it would be in his best interest if he would give you a deed restriction saying that when they sell the property, it would resort to residential. There would be no problem with that. And that it could only be used in that interim as an office space, which is what it is.
But correct me if I'm wrong, Richard, that isn't the question that's before us, right?
It is a
To
solution.
identify a deed
Where-
restriction.
Again, this is
This
a
is a zoning.
rezoning to general
Right.
commercial. This is not a development agreement where we negotiate. This is a rezoning. All the uses of general commercial are allowed. We don't do conditional rezonings. You don't impose conditions of that kind in a quasi-judicial proceeding.
Madam Chair.
Lenny?
Richard, could we leave this zoning as is and the city do a development agreement to allow this use?
A development agreement is not a by right option. The city would have to agree to do that.
I know, but could the city agree to do
They
that
can
if they requested?
propose a development agreement if they would like, and of course, a development agreement goes through the process where it gets a recommendation from you, goes on to the city council, and has to be approved by the city council by ordinance. It's not a small thing.
Well, this is not a small thing either. And secondly, as a realtor, I can only do so much for my clients, and then they have to do that for themselves as well, and go in and get the information for themselves. And it was not clear and concise as to the information that he needed to know. It was misconstrued. So there is error on both sides of this particular issue. And we are attempting to do the right thing, and this is not inexpensive. This is a $5,000 issue for him above and beyond what he's already got invested in the property for an error of not having it rented. And I do believe that that part of this problem needs to be addressed.
As the applicant, do you have anything else you want to add?
Just want to thank the commissioners, and hope they can see it to be in favor of my daughter and myself to get this place rented out, because I don't want to tear it down, because that's what it would pretty much take if it was not approved. Be tear it down and just advertise it as a lot for sale.
Okay.
Thank you.
Yeah. So, Ms. Tryon, you're the one that signed up to speak. Do you
Yeah.
have additional speaking you want to do?
I think there's one other point that needs to be looked at, and that is if the council was to move in a different direction and put this into residential, there is an existing building on the property now that does not meet any of the criteria whatsoever to be residential. And a retrofit on that building, or to attempt to construct it into something that would be residential, would be in the excess of probably $200,000 or $300,000, which is now $200,000 or $300,000 more than the value of the property and the existing building that's there.
Okay, I just want to clarify one thing. We're not moving it into residential multi. That's what it is.
Right, well,
So the request is for us to make a zoning change on the property, not to put residential onto it, because that's what it is.
but the history behind the property
I
shows 62
I
years
understand
of
that
it being
part.
something other than what it is. And now we
Understand that.
have a difficulty between, if this was possibly Mr. Oxenhold, it wouldn't matter. He has plenty of money to bulldoze something over and change it.
Well,
But this person bought this with the understanding that he was buying an office building and that it could remain that way.
thank you. That's the only one that signed up. Does anyone else want to speak? Oh, I have the sign-ups up here, so if you were looking to sign up, you,
He signed up late. I saw him go do it.
Please have a seat and state your name, please.
For the record, my name is Randy Roulette, 2122 Northeast Quay. My mailing address is P.O. Box 301, Gladstone, Oregon.
More than we needed, but thank you.
Okay, and I just want to say that this is the property where the office is, this is the property where the house is, went with the property. That's the property I bought. Right here. This is the only multifamily property in the zone is right here on these two lots, which is a sixplex. This is the church, these are empty lots, there's a house here and an office here. There is no multifamily except here on the corner, which is great. I would like to have that be an office building, which has been for 50 years in Lincoln City. And I'm right next door here, and I think that's a great thing. I like the across from the community center. I like the street. It's perfect. I don't see it as a residential property. So, briefly, I looked at the packet, I read it. I agree with the planner that it should be approved. When I read the packet, and I've been on planning commission for 15 years prior to my term just expired in Gladstone, I really think that without knowing about the spot zoning, that it would be an easy pass. So that's my testimony. Thank you.
Thank you. Anyone else? Okay. Oh, sure. Just come up, sit down, and state your name.
I feel like I should introduce myself. My name is Catherine Sutton. I am the owner of this property. I have always, since I have gotten this property with all of my investments, I've always been under the assumption that I had the ability to perform, to do with this property what it was always meant to do and serve as an office building. I was always reassured by everyone, by the realtor, by my dad, by people within the city, always that I would be able to rent this out. And that's why I put all of my investments into this. And I just had the aspiration that I'd be able to go forward with this. And I put work into this. This is an office building. Of course it is. It had like law office written on it, and we washed that off, and there were desks in the rooms, and we cleaned it up, and my dad and I, we put so much work into it. It was mostly just the two of us. My dad did so well to fix it up. This is not a house. This is not a residential. It may be in its zone, but that is not right. This is an office, and we cleaned it up, and we repurposed. We didn't repurpose it. We revamped it so that it could fulfill its purpose in the future and continue what started. And I'm just really struggling to see how it's so hard that I can't do that. I'm sorry.
It's all right.
It's just, I was really hopeful about this, and now to have that crushed is really hard for me. Sorry.
Okay. Anything else you want to say?
I still want to be hopeful. This is really all I have. I don't want to bulldoze it. I don't want to try and like make it into a house. I really like this property. I like the big rhododendron bushes, and I like how nice it looks now with the walls I painted and the nice little frame, and I put in like my little mini fridge from college because I'm just a college student. I'm just trying to make it by and pay off my loans and all that, which is why we're here before you, which is why I'm here before you trying my best. But like, I don't know enough about properties or rezoning or taxes or anything. I was just really hoping that this would work in my favor for once, because a lot of times things don't really work out, and this was really a big hope for me. It was something that I was super excited about. and I hate coming forward with a sob story, but this is just how it is for me. So, yeah, that's about it.
Okay. Thanks. Thanks for coming forward. Okay. ORS Section 197.763, Paragraph 6A states that upon request, the Commission must either grant a continuance for no less than 7 days or hold the record open for no less than 7 days to permit any participant an opportunity to provide additional testimony, argument, or evidence. Does any person who participated desire to request a continuance to provide additional testimony, argument, or evidence, or request that the record be left open to submit additional written testimony, argument, or evidence? You want to leave it open? Okay. Does the applicant waive the opportunity? Oops, sorry.
Close the hearing in the record.
Okay. Close it before I ask them if they want to submit? Huh. Well, that's not on my sheet. Okay. Do I have a motion to close the hearing and the record?
So moved.
Seconded?
All right. All in favor?
Aye.
Any opposed? Okay. Hearing's closed and the record's closed. So, so I'm just going to skip that part about asking them. Now I can't. Why is that not in here?
Confuse you.
Yep, it's easily done. Okay, does the applicant waive the opportunity to submit final written argument after the close of record as provided in Oregon ORS Section 197.763, Paragraph 6E? You want to waive it? Okay. Okay, so we are going to now deliberate, and commissioners, you can consult city staff and the city attorney, but you may not ask them for any new evidence. Don't do that. And I'm going to ask the city attorney if you have any concerning legal issues that were raised during this discussion, or legal advice concerning the application of the law.
Just a brief thing is that at one point there was an allegation of negligence on the part of the city. The city didn't tell me this. The city planner didn't tell me that. I was not given a copy of this. It's pretty clear in the case law that a participant in a local land use proceeding must ascertain for itself from the local code what it is required to do to protect its rights, and that's Columbia River Television versus Multnomah County, City of Grants Pass versus Josephine County, that goes on. So there's another case that says it's the city of Salem, Loosely versus City of Salem, or Salem versus City Loosely, and in that case, Mr. or Ms. Loosely went to the counter and asked the planner to verify that they could have a, I think it was an auto dealership on the property that they were thinking of buying. The planner signed something. Turned out that was wrong. They had purchased, they had gone ahead and purchased, so they sued the city for negligence, saying you were negligent, telling me that we could do an auto dealership, and that wasn't true. And the court held that the city planner is not your planner. The city planner is the city's planner. If think about it, if you hired a private planner to give you advice, that private planner has liability insurance and malpractice insurance for what they do and the advice they give you. The city planner is not your planner, and the finding there was no special duty owed by the city to that person on the other side of the counter, so there was no liability on the city's part. And I'm not saying that's what happened here. What I'm saying is that we often have people come up and bring up something like this, which is irrelevant to this decision. Okay, so it doesn't matter. It's not relevant. The question before you is, should the zoning and the comprehensive plan map be changed from residential to commercial. And the inquiry for you is, how does that match up with the statewide planning goals in your comprehensive plan, and is it internally consistent with your comprehensive plan? You have the staff report, you have the map, and you can see that this is commercial in the middle of a section that's residential. So while we don't call it spot zoning anymore, you could find that the amendment to place commercial uses in the middle of residential is not consistent and compatible with other unamended portions of the comprehensive plan. But that's your decision to make. What I'm telling you not to give any credence to is these allegations of negligence on behalf of staff. The applicant has the burden to demonstrate they meet the criterion. That testimony is irrelevant and it's wrong. Aside from that, I'll answer your questions.
Okay. Any questions for staff or the attorney?
Yes.
Yes.
This whole idea of not being, what, that language that you keep using, is a new idea to me. Does it have force in law, this idea that you shouldn't go against your unamended plan?
Yes, that's what our comprehensive plan states. And when we do a rezoning, you're reviewing against your comprehensive plan.
But our comprehensive plan doesn't speak to this particular piece of property by any means.
Well, it does in the sense that it has assigned the RM zoning, or land use designation to it, zoning and land use.
And should it have not taken consideration of the fact that there was a professional use of that property at the time they zoned it residential?
Well, there apparently, and I don't have
I know.
evidence we have statements that in 1962 or whatever it was built and it operated as a attorney's office. So the argument is that it was a legal non-conforming use until apparently the illness and then death and then sale when the use was discontinued. So just because it was a legal nonconformity doesn't justify in and of itself a zone change. There's nothing in your plan about perpetuating nonconformities. It's actually it's just the opposite. Mm-hmm. Nonconformities are to be abhorred. Mm-hmm. Eventually, we want them to go away. That's why you have a plan. So if there was changes or whatever that they had sought, they're here for making an application for a zone change. But the fact that there was a legal nonconforming use on the property is not a basis for that.
Thank you.
Other questions? All right, thoughts? Josh?
Oh, I'm still staring at the map, I'm sorry.
Have any thoughts about this?
I understand both sides, the situation, filtering out what we have to consider and what we don't have to consider. And one reason I'm staring at the map too so much, because it is very consistent in the zoning in the area and even next to the parks. But there are some areas around it, so it's really a difficult decision there to call it. It certainly would break up that residential zone and area as we have it planned, which, as Richard says, and we know as commissioners, we try to stick to the plan and try to make decisions consistent with that to be long-term. I know we're just considering this as a zoning application tonight, and the evidence that we have presented to do that. I know it's not part of our conversation. I wish there were some other option to allow them to continue on with their improvements and use, but I don't think that's not what we're here to consider tonight, so.
Steve?
I just unfortunately think the comprehensive plan does not give us an option to rezone this. not, it would be a violation of the consistency issue.
Miles, thoughts? Use your mic.
I think it's unfortunate that it was used for a law office for 50-some years, and I would continue the use of the property.
Marcy?
Well, I think it's pretty complicated. I mean, I've lived in town a long time. I went to school at Ocean Lake and had swim lessons and swim team at the community center, and you know, I understand the wording of the actual zoning and that we have to stick to that, but I wonder where, because I know our comprehensive plan is quite dated. I believe it was last updated in 1984. Where does the reality of the actual neighborhood, regardless of the zone that was put on it? Because we have, you know, most of the buildings in town are older than our zoning and have been used for different things, and I know updating that is all part of our plan and part of why we want to keep it consistent. But I guess my point was, being familiar with the neighborhood, is I wouldn't be able to guess what that zone, it seems pretty mixed to me. Yeah, there's a couple houses, there's a church, and you got the big community center there. It's a quiet little street. But I do believe that the old Elks building was recently rezoned general commercial within the last couple years. And I wonder if that sets any precedent for that neighborhood. Yeah, it is surrounded by a little more general commercial, but that was a long time use of a giant building that could have been kept residential for multifamily, and it was rezoned even after not having the history of commercial use for 50-some years. So to me, it seems pretty complicated, and coming down to the actual wording in the comprehensive plan and what we're bound to make this decision based on. Yeah, I don't know.
Lenny?
Well, I'm rather large on the idea of we should all go along on the same plan. So on one hand, I hear what our attorney is saying. On the other hand, that area is not what you'd really call residential. It's kind of a mixed bag all in there. And you know, across the street's community center, which is certainly not residential. And what are those two little blue things that are drawn behind the church thing?
Those are structures.
Oh, okay. And so I could bring myself to agree with this because of the way the neighborhood is laid out, even though it goes against my grain to go around deviating against the plan.
One more thing.
Yep.
Looking at what fits with the comprehensive plan and what zoning is in agreement with it, that whole multifamily section right there is almost a triangle. It doesn't really have a lot of multifamily use. So I would think that, especially if we don't approve this, to consider looking at what appropriate zoning for that whole area would be, whether it's the R175 behind or adding a little bit more of a commercial option there, because I think most things would be conforming. So
That's not what's in front
I know
of
it's
us,
not
though.
this, but just, well, keeping that in mind, you know, if we're deciding it's zone multifamily and it's supposed to fit in use and not contradict what that zone says, but what's around it isn't necessarily that multifamily. It's really kind of the intent versus reality, which is what I'm a little stuck on.
Mm-hmm. Well, I'll just add my 2 cents. I don't like taking a lot in the middle of one zoned area and changing it to something else. I think that's as they say, a slippery slope, and who knows the number of folks who will come in and want to change their particular lot for some reason. I agree with the city attorney that non-conforming is something we'd like to get away from. We have a comp plan for a reason, and I agree it needs to be updated, but that's not what's in front of us right now. I would like amendments to be consistent and not inconsistent with our comp plan. So that's my thinking. Steve, you're leaning forward. Did you have something else?
No, I would just, are we ready for a motion?
I think so.
I would
Do you have one?
move to recommend to the city council that they deny this request, zoning and comprehensive map change request.
Do I have a second? I'll second that. Okay, all in favor?
Aye.
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 Do we need a roll call? Okay.
Yeah, I think so.
We need a roll call.
Joshua Brainerd,
Aye.
Steve Griffiths,
Aye.
Patty Crowan,
Aye.
Miles Schlesinger,
No.
Marcy Baker,
No.
Lanny Nelson.
Aye. Sorry, Jane.
Okay. Do we need a statement from the no?
We, I guess staff will write up a final recommendation, because this goes on to the city council. So, again, is there a scheduled hearing before the council yet?
Yes, January 13th.
So we need authorization to sign that, because I don't think we have another meeting. Oh, we'd have another meeting January 7th. I
Yeah, we
believe.
have one.
Yeah,
January 7th.
so we'll bring back something for you.
Okay, this is a tentative decision of the Planning Commission, and staff will prepare a final order.
Excuse me, I was incorrect. The city council hearing is scheduled for January 27th.
And we definitely have a meeting before that.
Yes.
And don't we have a planning commission rule that those who voted no have to explain?
Yeah, that's
Aye.
what I asked.
Yeah.
So, Miles, you need to just make a statement why you voted no in the mic, not to me.
I voted no because I feel that a building that has been used for a lifetime as a law office in a mixed-use area should be able to be maintained as an office facility, and especially when it was built before the city of Lincoln City existed, and there were lax codes at that time, and that's why I voted in favor of the
Applicant.
applicant.
Okay. Marcy?
I voted no because I don't feel that the use as is would conflict with the neighborhood, and considering that it is not suited for any allowed uses for housing, no closets, no bathrooms, no showers, no nothing like that, that it makes sense it's been used for that long, and yeah, I don't think requiring it to be bulldozed because of a time limit is the most efficient or best for everyone, best for the city.
Thank you. Okay, it is now 7:09 p.m. The hearing is now open to accept public comment on file ZOA 2019-16, the RCC zone creation. This public hearing concerns a city-initiated proposal to amend Title 17 zoning, Section 17.12.010, classification of zones, adding a new resort recreation commercial zoning district, creating a new chapter, Chapter 17.29, RCC Resort Community Commercial. Commissioners, are there any abstentions or disqualifications based on conflict of interest or personal bias? Okay, seeing none. All right, after the staff presentation, any person may speak for up to 3 minutes. If we have questions, your time responding will not be counted in your time. If you wish to speak, please print your name and mailing address clearly on the sign-up sheet on the table at the entrance. Please speak directly into the microphone and begin by stating your name only. If you have written testimony to submit into the record, please provide a copy to the clerk. Staff, please present your report.
Commissioners, my name is Anne Marie Skinner. I'm with the Planning and Community Development Department. This case, as has been stated by the chair, is ZOA 2019-16, the RCC zone creation. RCC stands for I just lost my
Recreation.
Resort Community Commercial. The Recreation Resort Mixed Use Future Land Use Map designation was recently adopted by City Council. And that is the comprehensive plan map designation for a certain area in the north part of the city. It was actually implemented for that north area. This zone creation does not implement any zone in any area. It is simply creating the zone. So, for instance, the city has a general commercial zone. We have a multiple family residential zone. We have an R15 zone. This is a new zone that will go into all those other zones. And so the hearing tonight is simply on the zone itself. It is not for designating the zone on a specific piece of property. That would come about at a different time when the applicant and the property owner would actually submit a zone change application for a specific piece of property.
Makes no sense.
This amendment was initiated by the Planning and Community Development Director pursuant to LCMC 17.88.020. And staff recommends that we conduct the public hearing and that the Planning Commission close the public hearing, make a recommendation to City Council, and direct staff to prepare the Planning Commission recommendation form for the chair's signature at the next hearing. The zone that is being created, as has been stated, is the Resort Community Commercial Zone. Per the requirements of the comprehensive plan map designation that was created, this zone has to be enacted with a statutory development agreement. Therefore, the language reflected in the zone creation also reflects the term statutory development agreement. And I point that out because the comprehensive plan designation requires that. Lenny's looking confused.
Very.
I will read directly. The Resort Community Commercial District is intended to implement the Recreation Resort Mixed Use Future Land Use Map designation. The district is an optional implementing district and may only be implemented with the negotiated ORS Chapter 94 Development Agreement, hereinafter referred to as Statutory Development Agreement. And that language comes directly from the Future Land Use Map designation. So the comprehensive plan map designation that was adopted by City Council requires that this zone be enacted with a statutory development agreement.
So it would never appear on a map unless a developer came in and initiated that agreement?
Correct.
There are actually, there's more than one way to develop a piece of property with the RRMU flume designation. One way is with the existing R1 7.5 zoning that's on the property. You can do development by right under that zone. That's not going to give you much in terms of commercial uses, because R1 7.5 is a residential zone. The only way you can get any commercial is to do a planned development, and then you get 15% of the area as commercial. The other way to develop, well, two other ways to develop would be for the city to create another implementing zone, not this one, and the future land use map designation, which was adopted and the ordinance is included in your packet. When it created this designation, it said you can have this RCC with a development agreement, or the city can create another by right zone. We haven't done that yet, but we have created the development agreement. You do know that we amended the comp plan to allow the use of development agreements. We did a development agreement ordinance. This is the zone that goes along with the development agreement. So this is one of the options, and this is not the option you get to demand by right. This is the one that you say, okay, I want to come in and negotiate, work with the city, and in a negotiation and a development agreement, this is the implementing vehicle.
And this is targeting the formerly known as the villages.
Well, it's not targeting the villages specifically. It would be targeting the area in the villages that has been adopted and designated as the recreation resort mixed use designation on the comprehensive plan, which is approximately 23 acres.
But again, there are three ways for that property to develop.
Right, because it's currently R175, right?
So this RCC zone is one of the ways it can develop. So we're creating an option.
Right, okay. Proceed.
Can I ask a further question along that line? What is it about the statutory development thing, excuse me, idea that we've come up with, all to me new? Why do we want to encourage people to do statutory development? And why don't we, and then the other half of that question really is, why don't we just zone this RC and call it good?
Well, let's take your first question first. The last question. Why don't we just do RC? Well, if we do RC, you remember a couple months ago, you had an application come in where somebody asked for, was it RC, the Cho property? That they
Yes.
came in and asked for RC, and one of the things you sat here and said is, well, they're asking for RC, and here's the long list of things you can have in RC. So we have to look at all these uses. I know that they said they're just going to do a duplex or whatever, or VRD, but they don't have a contractual commitment to just the duplex or just the VRD. So that's what a development agreement can give you. It can limit the uses from all these uses to these, which is what we agreed to in the development agreement. So that's one reason to do a development agreement. It's good for the applicant because you don't have to look at the impacts of all these other uses. You can just look at the ones that they want. It's good for the city because staff doesn't have to analyze the impacts of all those different things, and we can narrow it down to what we want. Other reasons why development agreements are used is that from the city side, we can ask for things that we wouldn't be able to compel them to give. When we ask for road improvements or street improvements, utility improvements, we're limited by case law. Dolan and Nolan requires that it be rationally related and have a roughly proportional and a nexus and all that stuff. Well, when you negotiate, you're not strictly tied to those. So you can ask for more. Same thing on the part of the developer. If the code allows relief through a development agreement, they can get certain relief. Usually, a development agreement gives you a longer timetable. Most of our timetables of development in our code are or 2 years or something like that. A statutory development agreement can go up to 15 years. So there's trade-offs on either side.
Okay, but when you say we can agree to this, that, or the other, who is this we?
The city council. Development agreement has to be approved by ordinance. And if you recall from when we reviewed this, and you asked me the question, who negotiates it? What your role is to make sure that any variance, any modification of the standards is specifically authorized.
Well, I'll try to limit one more question. There are no standards for RCC. There's no height standard, there's no et cetera standard.
There are, well, the height standard is, so going through the
What's in the city
list
charter, yeah.
of what's in there, there's a 2-page list of uses that are permitted in the proposed RCC zone.
Oh, okay. I didn't quite understand how that went together. Okay.
Yeah, so if you look at page 73 and page 74 of the packet,
Okay.
A, B, C, D, and E are all permitted uses proposed for the RCC district. Now, in the development agreement, the developer would select from any of those uses. And then if there are other uses that aren't on this list that they wanted to do as part of the development agreement negotiation, they could potentially request those uses in return for X, Y, and Z that the city would give or not give.
And you see that if the city negotiated with a developer and the developer wanted relief from landscaping requirements, and it comes to you and you see that the landscaping isn't up to the regular standard, well, you look at this and you go, oh, it says here landscaping shall generally comply with 1752-100 except that landscaping requirements may be varied in a development agreement. Okay, then. This specifically authorizes variance of landscape standards in a negotiated development agreement. So you can find that it's consistent because it's allowed. It says right here, we can vary it if it's in a negotiated development agreement. Now, you can recommend against it, but if, in terms of finding that it's authorized, you find the language right here that it's authorized. But if we varied something else, like lot coverage or something that says here, there is no variance, if we varied that and it comes before you, to be like, hey, that's not authorized, so can't approve this.
Question. I kind of like this in concept. I'm not sure we have strong enough standards in it yet. In particular, in regard to preserving the natural environment, the open space that would be associated with the RCC zone. Is that correct? And for example, you mentioned we'd like to preserve wildlife corridors. How do we define what a corridor is? How do we know how large or wide that corridor needs to be in order to really truly function as a wildlife corridor? So I think we need standards in this. Secondly, we talk about streams and protecting wetlands. How are we going to protect them? How large is a buffer going to be? And I think before we approve this, or the city council approves it, or we recommend it, we need to know what a natural history scientist would say. If you have a stream there and it's got salmonids in it, you've got to have a buffer on each side that's at least this in order to make sure you protect that natural environment. So I think we need standards in here, and there are none present. You know, I may think a buffer or a wildlife corridor should be 50 yards wide. Somebody else might be thinking, oh, you just need 5 yards. So we need a standard here.
If you look at 1729-70, it says environmental protections. There shall be
What
no
page?
packet page 76. There shall be no modification of environmental protection regulations in the city code except that a statutory development agreement, the minimum amount of relief necessary may be granted when it is necessary to access the property or if necessary, to avoid a taking of all reasonable economic use of the property.
Do we have stream buffers defined in the city code as well as wildlife corridors? Is that addressed?
I believe we have Goal 5 regulations. I'm not sure exactly what they are.
We do. We have the Natural Resource Overlay Zone, which identifies riparian areas, wetlands, aesthetic resources, which are trees, and there are parameters given for all of those in that chapter in Title 17. Additionally, the area that was designated the RRMU does not contain any riparian, does not contain any aesthetic resources as identified on our comprehensive plan map. There's a small portion of significant wetlands, but other than that, that 23 acres does not contain any of the environmental items identified on the comprehensive plan map.
And just remember that that's by design, that the RRMU flume designation, the land use designation that we put on about 23 acres, that's not really before you right now, but the only property that could get this zone right now, in order to get this land use designation, they had to set aside 1.5 times that property as open space. And when it left you, that open space was going to be the knoll. When it got to the city council said, no, we're not going to count the knoll. We're going to add 35 acres to the east of the knoll. So the knoll got basically twice as big. And now the ordinance that adopted that applied that land use designation directed that staff bring forward an open space zoning amendment for 35 acres next to the knoll. So that, what I'm trying to say is that what's contemplated is that the corridors and the preservation of native habitats and wetlands and sensitive lands is mostly contemplated to be off-site because we're setting aside additional properties.
And so this particular area, which is 25 acres?
23.
23 acres?
Not quite 23.
Could be cleared.
Well, but if there's a wetland on the corner, it's going to be preserved, and there's going to be a buffer on it. But if, you know, we wouldn't...
Every tree can all be taken off.
No, that's not what was said.
Well, that's what, I mean, that's why we're asking.
Again, there can be relief from landscaping regulations in a negotiated development agreement. But if it comes in as a straight subdivision in R1 7.5, no. In a development agreement, in the context of that negotiation, there can be modification of landscaping. Does that mean everything gets cut down? No.
Yeah. Well, I think what maybe, and I don't mean to put words in your mouth, Steve, but I think what maybe you're struggling with is what I'm struggling with, is that we looked at that development up there with the intent of it being ecologically sustainable and sort of focusing on preservation of the environment up there as much as we could. Mm-hmm. So large trees, don't cut down every Sitka that's up there, and try to be mindful of the elk herd that lives there and their corridors that they use. And so we're just trying to figure out if that's in here somewhere, and if it isn't, if there's some way to make it so.
Well, I believe that the bulk of that would be addressed in the other 300 acres that's designated for residential. And that's where, when you look at the natural resources overlay zone, that's where most of the riparian, wetland, et cetera, is located, not this 22 acres.
Does the tree ordinance apply to this?
Yes.
The existing crazy, difficult to figure out tree ordinance that we currently have?
Not mine.
But going back that we're creating a zone, we're talking about a particular area. But what if you're just in concept, you're creating a zone? How do you use this to ensure that in fact, you know, corridors are preserved and what they mean in that context, independent of, you know, the north part of Lincoln City? You know, if it's going to be implemented
Well,
somewhere else. Yeah.
The first thing is this zone can only be utilized on something that's has a comprehensive plan map amendment or comprehensive plan designation of the RRMU.
And that's the only place that it occurs.
That is the only place in the entire city that has that designation.
Now,
And in order to get that designation, you have to dedicate as open space
Right.
1.5 times the property that you're seeking to be
right,
rezoned.
so
And
is
that's
the
where you're-
assumption that that is
and-
not going to happen anywhere else in the city or in any land that the city may acquire in the future?
Well, it's not an easy standard to meet.
It's highly unlikely.
Okay. Other questions? Do you want to continue? You have more
There-
or not?
No.
Okay, I have a question. The bottom of packet page 75, there's subsection J. It talks about outdoor displays of goods and materials for retail establishments. Isn't that currently illegal in the city of Lincoln City? I know there are some enforcement issues about it, but isn't it currently not
No,
okay?
it's allowed in the general commercial zone.
I thought when we were talking about design standards and the sign ordinance and all of that, that it was highlighted that display of goods for sale in a store are not allowed to be outside.
In the general commercial zone, it's allowed.
So why is it coming up in this
It's not-
recreational?
It's not permitted in the right-of-way, and probably the thing that you see is that sometimes people are sneaking those things out onto the sidewalk, and the sidewalk may be the right-of-way, but there are outdoor displays allowed in the code. It's,
Okay.
outdoor commercial, no, I'm sorry, wrong one.
So this would also be the only area in the city that would have residences that are 45 feet tall and high?
Residential uses are not allowed in this zone. The only residential use that's allowed is commercial ground floor with residential above.
And those buildings could be 45 feet.
Yes.
Right, okay.
1732-110C, outdoor sales displays. Outdoor sales displays are allowed. This is the general commercial zone, but shall not be located in a yard, landscaped area, or off-street parking or loading area. So it is allowed.
Okay, it's just not allowed in like the parking landscaping within a parking lot.
Or the right-of-way, yeah.
Which is where they are. Okay. Any other questions on this? Concerns, issues?
I'll just, again, just remark that this is about a negotiated development agreement, and it facilitates the development agreement, and it authorizes a certain degree of variance from the terms of the code. Now, staff doesn't have to agree. The applicant could come in and say, I want this, this, and this, and we could say, no, it's not, and we're not going to recommend that. So ultimately, if we don't agree, there's no agreement, and it doesn't go forward.
If you don't agree, we don't get to
Well,
participate in that.
No, it's the council's decision.
Right, okay.
Madam Chair?
Yeah,
The problem I have is you're not always necessarily going to be the city attorney, and you're not necessarily always going to be the planning director, although I'm happy to have you. But, so, not everybody agrees to be so kind and generous about environmental. That's why I'm a little nervous about these development agreements, because if different people come along and they agree that you can do anything you want and it doesn't hurt anything, and believe me, I've heard that, then how do we contain that?
Well, that's why we wrote the words that I read earlier, no modification of environmental protection regulations except when necessary for access or to avoid a taking. Basically, if you can't use your property except to get relief from environmental regulations, then we'll grant such relief as is the minimum necessary to allow economic use of the property. And that's written here. It's not based on me, it's
No.
in the code.
And you think that's strong enough?
The current code in the natural resource overlay zone prohibits development in a riparian area significant wetland, flat out prohibits it. You can't do it. You have to apply for a natural resource variance, and you have to prove just exactly what this language is, that you're using the smallest amount of property possible to still maintain your property right, and avoid a taking, but preserve the significant wetland and the riparian area, et cetera. And our current code requires that.
Okay, so just a hypothetical. If somebody purchased a wetland and then came into the city and said, I want to develop this, and you said you can't because it's a wetland, is that a take?
Well, I would argue no, because, you bought the wetland. But that's probably, we could probably spend hours talking about that issue.
And it would make the planning commission happy to know that the variance that would allow that development would come before the planning commission.
Yeah, that
Well,
makes
the planning commission's come and go too.
So
That
you
makes it all
would
better.
make the determination whether or not it was
Yeah,
a take.
Some of us are old and would always be here.
Okay,
And remember, there's a larger program here. Again, the RRMU ordinance, which is attached to this agenda, includes I didn't come up with the other name, residential mixed structure, there's another acronym.
For the
there.
residential designation.
And 305 acres got that designation, actually applied to it up at the villages. So the implementing zoning for that, because, as Anne Marie said, probably most of the environmental resources are on those 305 acres. Now, we know 35 of those acres just got directed to be set aside as open space. So less than that now, but
And the implementing zone for the 300 plus acres will become, we have not written that yet, but that will have stronger standards, and that will have the defined standards because, as Richard said, that I said, agreeing with me, the bulk of the significant wetlands, the riparian area, the wildlife corridors of the trees are on that 300 plus acres, not this 22. This 22 only contains yes.
And remember, the idea is that you look at, in all land development, you look at what you have, and then you set aside and protect the environmental resources, and that leaves little circles, little pods around that aren't restricted. And those are the parcels you sell, okay? You don't sell the ones that are wetlands, you sell the ones that are the unrestricted ones. And then you simply get a contribution, just like a homeowners association would, to maintain all those common areas. So you don't want to sell the wetlands, you want to sell the pods that are free of the regulations or the restrictions, and then get a contribution to maintain the common areas.
okay, anything else, Anne Marie?
I have nothing else.
Does anybody in the audience want to jump into this? No one has a comment on this? Okay. Is there a motion to close the public hearing in the record?
I'll move to close the public hearing in the record.
I'll
Second.
second that.
Okay, all in favor?
Aye.
Aye.
Any opposed? Nope. All right, what's the pleasure of the commission? I have a motion?
I motion we approve the, citywide zoning code amendment as presented.
And to recommend it to the city council for approval.
Second.
Do we need a roll call vote? Okay, let's do it. Roll call vote, please.
Joshua Brainerd,
Yay.
Steve Griffiths,
Yes.
Patty Crowan,
Yes.
Miles Schlesinger,
Yes.
Marcy Baker,
Yes.
Lenny Nelson.
Yes.
Okay. So that will come back to us as a final recommendation or not?
Yes.
Okay. Moving on. It is now 7:41. The hearing is now open to accept public comment on file ZOA 2019-14 ADU cleanup. This is accessory dwelling use cleanup. Not to clean up the accessory dwelling uses, but to clean up the language. The public hearing concerns a city-initiated proposal to amend Title 17 zoning in Chapter 17.08 by revising the definition for accessory dwelling units to be consistent with state code, revising Section 17.80.110 to provide clear and objective language, and remove inconsistencies throughout Title 17 in reference to accessory dwelling units. Commissioners, are there any abstentions or disqualifications based on conflict of interest or personal bias? Okay. Same rules. After the staff presentation, any person can do, what's up?
Chair, I believe on the agenda.
Did I,
the bluff
well, where
setback
is it?
amendment is.
James, these were out of order. Okay. I'm sorry, I'm sorry.
I was
Okay,
wondering what everybody was waiting for.
Let's start over.
page are we
ZOA
on?
2019-12 Bluff Setback Amendment. Is that what everybody's here for?
Yeah, I was
Great,
wondering.
okay. It's now 7:43. The hearing is now open to accept public comment on file ZOA 2019-12 Bluff Setback Amendment. This public hearing concerns a city-initiated proposal to amend Title 17 zoning in Chapter 17.47 by adding maximum to annual erosion rate and by providing guidelines for determination of the bluff location, measurement of the bluff setback, and prohibiting alteration of the bluff edge. Commissioners, any abstentions or disqualifications based on conflict of interest or personal bias? Okay. After the staff presentation, anyone is going to be able to talk for up to 3 minutes. If you have questions, if we have questions, your time responding to our questions won't count against you. If you want to speak, please print your name and mailing address clearly on the sign-in sheet at the table at the entrance. Please speak directly into the microphone. Begin by stating your name only, and if you have written testimony to submit into the record, provide a copy to James. Staff, report.
Thank you. Anne Marie Skinner with the Planning and Community Development Department. This is a citywide zoning code amendment for the bluff setback. The applicable public notice was mailed on November 26, 2019. The relevant substantive criteria is LCMC 17.88.020. City Council requested this zoning code amendment, and they requested it to provide clarification on determining the measurement line for bluff setbacks. Specifically, the current language does not provide a clear direction for unaltered versus altered bluff setback, and this amendment specifically adds a sentence stating that the bluff setback must be measured from the unaltered bluff edge, as based upon a recent meaning conducted within the 12 months prior to the date of the geotechnical analysis, topographic survey performed by a land surveyor licensed in the state of Oregon. A statement has been added that the alteration of the bluff edge is prohibited, as well as clarification that provided reports must be from an engineering geologist licensed in the state of Oregon or a registered engineer licensed in the state of Oregon, or both. And that is essentially It's a very simple amendment. The code currently exists that provides requirements for a geologic report when construction takes place within the bluff hazard zone, and that is about a 6-page long ordinance. There are a number of requirements for that geologic report. None of those are changing. All this amendment is doing is adding a few simple items. Specifically, the bluff setback must be measured from the unaltered bluff edge as based upon a recent topographic survey. Alteration of the bluff edge is prohibited. We've added the word maximum so that the sentence now reads, the footprint of any other new structure or any horizontal addition requiring at least 1 footing in ocean bluff areas must be set back from the bluff a distance of at least 60 times the maximum annual erosion rate. That is as determined by the geotechnical analysis plus 5 feet. All of that exists in the code right now with the exception of the word maximum.
Does the code currently identify that it needs to be the reports from an engineering geologist or a registered engineer, not a registered geotech engineer, just any old engineer?
Correct. The code currently states, and this is what it says right now, provided in a report from an engineering geologist, a registered engineer, or both. And so this language adds an engineering geologist licensed in the state of Oregon, a registered engineer licensed in the state of Oregon, or both.
An electrical engineer? I mean, I know it sounds silly, but you know, that's like going to an eye doctor for a foot problem. If you are looking at a registered engineer, they have specialties that are associated with this type of work.
Agreed. And Planning Commission could certainly make the recommendation as part of the recommendation to strike a registered engineer.
Well, I wouldn't want to strike it. I would want to be more specific to a geotech or a civil.
Certainly. And that's certainly within your purview to make that recommendation.
Could we
Okay.
change the word registered engineer to registered civil engineer? Is that what you're driving at? Would you like to see
Civil
something
or a
with that?
geotech,
Well, the first one
engineer.
says engineering geologist
right, but that's not,
or a registered civil engineer licensed in the state.
I'm not trying to be picky here, but a registered geologist and a geotechnical engineer are two different
They're
animals.
different. Mm-hmm.
So
Well,
I would prefer to have a specific engineer that has specialty in this, which is a geotech or a civil.
I think that
just say
change,
civil.
recommended change makes sense.
Mm-hmm.
so it'd be a registered geotechnical engineer licensed in the state of Oregon. Is that what you're attempting to get to?
Registered
civil.
geotechnical or civil engineer. Two different animals.
I don't think you want to leave out the registered licensed in.
No, I'm not leaving that out. I'm inserting 2 other words in addition to registered and engineer.
In the state of Oregon,
Mm-hmm.
Sure.
And staff concurs. That's a very good recommendation.
Okay.
Can you, I was trying to find the ordinance in the packet, I couldn't find it.
Page 106.
You said a registered geotechnical engineer, is that the word you wanted to add?
Geotechnical or civil. Those 2. Okay. Anything else, Anne Marie? Questions
it.
for Anne Marie? Any? Okay. I don't have the sign-in sheets for people who wanted to speak. Do you have them? Okay. Okay, Benjamin Brown. No Benjamin. Okay, Pam Lind. Evening.
Evening. I'm Pam Barlow Lind.
You can pull it towards you.
That's easier.
There you go.
So I'm not having to look like a crow. I'm Pam Barlow Lind. I'm the tribal planner for the Sluts Tribe, and we were interested in this agenda item, and because of our own priorities, we haven't had much time to be able to look at this, so we were just wanting to ask if the record could remain open so we could take a little deeper look at it. It seems like a good idea. I liked your suggestion about the engineering geologist or civil engine or
Speak up,
civil.
please.
I'm sorry. We were hoping that the record could remain open so we'd have an opportunity for my department to take a little more time to look at this and just provide some feedback if we have it.
Okay,
That's really all I have.
okay, thank you. Did anybody else in the audience want to speak on this?
Mother Nature.
That's an excellent question.
Well, again, this is a text amendment to the comprehensive, or to the city's regulations on hazard areas. It's possible if you come in and see the planning department, we may be able to pull it up on a GIS and figure out if it's in fact the state of Oregon's responsibility, because, you know, they manage the beaches. And there is some complicated formula about where their jurisdiction starts, and I don't remember it off the top of my head, but
It's a vegetative line.
yeah, we can probably help you at the counter. This probably isn't the place to do it.
If there's an existing, we want the house, the previous owner to build a fence along, it's like, fence is holistic, it's a wooden thing along the edge of the lot that is there and it's falling apart. Are we clear to make a better one, or should it never have been there to begin with?
I think
And
that's a question
something,
you want to
again,
come in.
that, yeah, if you come into the office tomorrow, we need to pull up your property on the GIS map and probably have a discussion with Public Works, as I noted prior to the hearing, and we can address those questions in the office.
Okay,
Commissioners, I'll just add one thing, is that the reason why this amendment is before you is because the city council asked it to come back through. And you know that the reason why is because there was ambiguity in the code. We had an applicant come in and propose to measure the setback by the altered bluff that they showed on their grading plan, as opposed to the unaltered bluff, which is what the neighbors wanted it measured from.
Right.
And that is before the Land Use Board of Appeals. And the council figured, we don't want to do this again, so let's amend the code to make it clear. So that's what we're doing. Whether or not it says altered or it says unaltered, that's what, we're going to be clear about it. So
Right.
that's where we are.
okay. Other questions?
No.
Okay, and so I have a motion, I could have a motion to close the public hearing and keep the record open?
Yes, since the tribe has basically requested that we leave the record open, I would recommend you do that. Then you could continue, you wouldn't deliberate, then you would
Right.
just continue deliberations to a date certain, probably your next meeting.
Right, and that would provide, there you are, that would provide an opportunity for you to spend a little more time with this, take a look at it, and consider if you want to submit additional information.
And your next meeting is January 7th. I don't know if you want to do that meeting or the second meeting. It's scheduling, up to you.
Well, this is the holidays, so that would be sort of pushing them. I'd say the second meeting in January.
Okay, so when you set a time for the record to close, just keep that in mind.
So we close it 7 days before?
No, it's up to you, as long as it's not subject to that statute on the minimum 7 days, so it's just whatever amount of time you think is convenient.
Okay, so our next meeting's on the 7th, and then we have another one on the 21st. So if we can set to close the record on the 14th, that would then give you a couple weeks into January. Does that work for everybody? Okay, so I need a separate motion to close the public hearing, right?
Yeah.
Okay, do I have a motion to close the public hearing?
Close the public hearing.
Okay, do I have a second?
I'll second.
All right, all in favor?
Aye.
Any opposed? No. Okay, and then I need a separate motion to keep the record open until January 14th.
So moved.
Seconded.
All in favor?
Aye.
Aye.
Any opposed?
And then deliberations will be continued to January, I don't know what the date is.
21st.
21st.
Yeah. And we don't need a motion for that?
You can do that unanimous consent if you
Okay,
want.
do I have unanimous consent to deliberate on this on January 21st?
Yes.
Yes.
Excellent. Anybody opposed to that? Okay. All right. It's a long agenda. Okay, now I'm at the ADU cleanup. So do I have to read all of it again, or can we all remember where we were? We have no conflicts, no biases. Staff, after the staff presentation, if you're interested in speaking, you have 3 minutes. If you want to speak, put your name on the list. And if you have written testimony, you can submit it to James. Staff. ADU cleanup.
Thank you, Chair. Anne Marie Skinner with Planning and Community Development Department. And this is a pretty simple ordinance. About 2 months ago, the Planning Commission and City Council adopted the revisions to the accessory dwelling unit ordinance that struck the requirements for off-street parking and for owner occupancy based upon the state's recently passed House Bill 2001. Part of the process of the land use ordinance amendments is that notification goes to DLCD, Department of Land Conservation Development. And one of the things they noticed in our existing accessory dwelling unit ordinance is that there was some subjective language regarding design standards, and they strongly suggested that we remove that subjective language, and that is essentially what this ordinance does. So it revises the definition of accessory dwelling unit to be consistent with the state's definition, and that is listed as accessory dwelling unit means an interior attached or detached residential structure that is used in conjunction with or that is accessory to a single-family dwelling, and that includes permanent interior provisions for living, sleeping, eating, cooking, and sanitation. Yes.
And it deletes that it is smaller than the single-family home, right?
It's because it's really poor ordinance writing to include standards and specifications in the definition. Those should be included in the standards and specifications, which the size is.
So in the standards and specifications, the size is identified as smaller than the
It's
primary?
It's a maximum of 750 square feet or 50% of the size of the dwelling, whichever is less.
Okay, okay. Thank you.
So the definition, that's the first thing, and that's simply making it consistent with state code. And the rest of the items in here are changing primary to principal. That's specifically making it principal throughout the entire ordinance so that some doesn't say principal and some doesn't say primary. We get down to item 7, which talks about design. That is the subjective language that the state requested that we remove.
So that isn't even in the standards, correct?
Correct. And then the rest of the ordinance is just making it all consistent throughout all the zones so that it's listed the same.
Okay. Is that it?
And that's it.
All right. Questions for staff?
Madam Chair?
Yep.
This can be a rental unit then, right? In other words, if I live in a house and I've got the room to put one of these on, I can rent it out to anybody who comes along.
Yes.
Okay.
But not as a VRD.
No, not as a
Correct.
long-term rental.
Okay. Other questions for staff? No? Okay. Does any member of the audience want to speak on this? Okay. Is there a motion to close the public hearing in the record?
I'll motion to close the public hearing on the record.
Do I have a second?
Second.
All in favor?
Aye.
Aye.
Any opposed? Okay. What's the pleasure of the commission?
I make a motion to recommend ZOA 2019-14 for city council consideration and direct staff to prepare the planning commission recommendation for the chair's signature.
Do I have a second?
Second.
All, roll call vote.
Sorry, I'm catching up. Okay, Joshua Brainerd.
Aye.
Steve Griffiths.
Aye.
Patty Crowan.
Yes.
Miles Schlesinger.
Aye.
Marcy Baker.
Yes.
Lenny Nelson.
Yes.
Okay. Put it together and we'll sign it. Does that have a date for the city council or?
Yes, it
I think there's one built in there.
is January 27th.
Okay. So we have time. Mobile food carts? Okay. It's now 8:04. The hearing is now open to accept public comment on file ZOA 2019-03 mobile food carts. This public hearing concerns a city-initiated proposal to amend Title 17 zoning by adding a new section 17.80.160 mobile food units, establishing standards for mobile food units and mobile food unit pods. This amends several zones: the professional campus, recreation commercial, general commercial, the Nelscott Planned District, Planned Industrial, Taft Village Core, Ocean Lake Planned District, and Park to allow mobile food units and mobile food unit pods. Commissioners, are there any abstentions or disqualifications based on conflict of interest or personal bias? Okay. After the staff presentation, any person can speak for up to 3 minutes. If we have questions, your time responding will not count against your time. If you wish to speak, I have the list up here. If you're not on it and you still want to speak, you can. And if you have any written testimony to submit, please provide a copy to the clerk. Staff, please present your report.
She gets her 10,000 steps a day just walking back and forth.
Anne Marie Skinner with the Planning and Community Development Department. This is case ZOA 2019-03, mobile food units. This is a zoning code amendment initiated at the request of City Council to provide for mobile food units and mobile food unit pods as allowed uses in certain zones. Currently, Title 17 does not contain definitions of or allowed uses for mobile food units or mobile food unit pods. This proposed amendment would add a new section, which is section 17.80.160. The new section contains a definition for mobile food units and mobile food unit pods, as well as standards. As the chair stated, this amendment also adds them as permitted uses in a professional campus, recreation commercial, general commercial, Nell Scott Plan District, planned industrial, park, Taft Village Core, and Ocean Lake Plan District zones. By way of background, the Planning Commission has held numerous work studies on this particular topic. City Council held a work study in November, I believe it was, made a few changes to the some of the items that Planning Commission had previously indicated that they wanted included in the draft amendment. So as you're reviewing the draft amendment, some of those items that aren't there, that is the reason why. And there are two portions to this. The land use portion is in Title 17, and that is what is before you tonight. Some of the requirements come with the licensing. The licensing is in Title 5 of the City Code, and Title 5 is amendments to Title 5 are not heard by the Planning Commission. So specifically, one of the items that is not in the land use standards in Title 17 pertains to the use of biodegradable packaging, and that is included in the licensing portion in Title 5. And I included that in the packet so that you would be able to see that that is contained as one of the requirements, and I'm trying to find which number it is.
Yeah,
It is.
page number would be helpful.
It is,
129.
I've got it, 134.
Oh,
Can I ask a question about that?
Yes,
Can we make recommendations to changes in that at this point? No.
in the Title 5?
Yeah.
No.
Yeah, okay.
So it is on packet page 134. It's item F. Mobile food units must utilize biodegradable packaging. No plastic or styrofoam-based packaging of products is allowed to be provided to the general public.
As a member of the public, you can, of course, send in your comments to the City Council on the
I'll
ordinance.
do that. Thanks.
well, I was curious. Apparently, we're not going to look into this. But one, I thought I saw in here, I didn't quite understand it, that the people who are on private property have to give the city gross income and a number of other things, which we don't normally require from any other business in town. I was wondering why.
There are requirements in Title V for providing through concession agreements, et cetera, that yes, there are portions of the income that have to go to that.
I'm not talking about the ones that are concessions that are on city land. I'm talking about the other ones.
Is this pertaining to the Title V?
Well, that's where I was trying to figure out where I got
or
the
is it
language.
pertaining to Title
I
17?
believe it's in the license ordinance, and it talks about you pay a concession for a parks concession, and that's also in the city parks regulations, so that's not really anything different. It's just specifically allowing it for mobile food units. I don't know that it has, that would be in here, that we wouldn't collect a concession for operations on private property because you're not using public property.
I didn't think so. Okay, thank you.
So is the waste recycling also in the licensing part?
That mobile food unit vendors shall pick up any food waste, paper, cardboard, wood, or plastic containers, wrappers, trash, debris, and/or any litter in any form which is deposited by any person on the sidewalk or street or other property within 35 feet of a mobile food unit, et cetera, et cetera. Is
Yeah.
that what you're referring
Yeah,
to?
yeah,
Yes,
yeah.
that's in the license.
licensing.
Mhm.
Okay.
Wastewater shall be properly disposed of, which does not include disposal in a storm drain or on the ground.
Okay.
The other one that I was, and now I didn't find my source here, packet 132B, we require these, this type of use to have insurance, which is, I'm not opposed to that by any means, but I'm not aware that we require any other business to necessarily have insurance.
Street vendor carts require that.
And this, again, the licensing ordinance isn't before you, but it is very much patterned on the food cart license that's currently in the code. And we went through an effort last year to revamp that and update it, so.
Okay, well, I wasn't part of that, okay. Okay.
Okay, so
Other
we're not really
questions?
discussing anything in this, in the license part, that's just for our information of what's in there, so it's really just the
Correct.
first part.
That's
Okay.
right.
Well,
Yes.
I think we just wanted you to know that things that you had asked for, actually, some of them got stuck in the
That they're
license
in
ordinance, yeah.
Instead of Title
Oh,
17,
Yeah,
that makes
and
sense.
that's why I included it, so you didn't think that your comments were going unheeded.
I did have one question, I'm just
Yeah.
not sure which one it fell under.
Okay. Ask the question.
It's where it talks about only class 3 and 4 are allowed, and then there was another statement of, well, it just seemed like class 3 allows anything under class 2, and class 2 allows anything under class 1. So it really, I was kind of wondering what the intent of only discussing class 3 and 4 food units is. Is it that we're, because the difference is that those both require cooking, or, well,
That came up in the work session, and that was something that the planning commissioners wanted to specify, that the only mobile food units that would be allowed are class 3 and 4. Class 1 and 2 are not.
right. I was just a little confused, because if I were looking at opening a food cart, I would look at that, and then I went to the state standards of what are the different classes, and class 3 allows 2 and 1. So,
So maybe you want to say class 1 and 2 are not permitted.
well, the difference would be that those two are prepackaged food, they don't
Right,
require
we
cooking.
didn't want
and-
those permitted.
Yeah, so I think something that
That prohibits those.
specifically
Yeah,
says just
okay.
3 and 4,
Probably
and
a
not
good-
what the state says about 1 and 2.
Okay.
I'm curious why we wouldn't want 1 and 2. I mean, why do we care if they sell prepackaged sandwiches?
As I recall, and you can correct me if my memory is faulty here, but we were talking about trying to keep from having just a push cart with somebody selling Twinkies that are already wrapped, and it's not really a food cart per se, as we think of food trucks. When you go to Portland and you think of a food truck, that was sort of what our intent was,
Like a little paper
where you
thing.
got a meal instead of,
Okay.
something that they're purchasing from someplace else. And
Really,
then-
the intent
and
is
then
we're looking for the carts that actually going to be cooking.
Right.
Well, I was involved preliminarily in some of those discussions as well, and I remember specifically that 1s and 2s, the discussion revolved around the fact that there wasn't a way to separate out things like plastic wrap and things like that. So it didn't meet the intent of our, recycling and our environmental initiatives
That's
with
true.
that.
That's a
So-
good
It's
point.
getting
I
onto
forgot that
single-use
part.
plastic since,
Right.
yeah.
Okay.
Okay. Other questions for Anne Marie? Okay. Leslie Fortune? Leslie? Oh, you signed up, but you're just here to listen. Okay. So you didn't sign up, but you want to talk? You don't want to talk? Oh, but you're good.
Oh,
do
come
you
on up and
know?
talk. We're lonely.
That's our plan. We just wear you down with the long
We
meeting.
insist.
All right, does anybody want to talk? Nobody wants to talk. All right. Is there a motion to close the public hearing in the record?
So moved.
And do I have a second?
Second.
Okay, all in favor?
Aye.
Any opposed? All right, pleasure of the commission. We've had a lot of discussion on this over the last few months with joint work sessions, and yeah, it's been a long road to get to this point. So what's the pleasure of the commission?
I'm ready to eat, so I would like to, I would like to move to recommend ZOA 2019-03 for city council consideration and direct staff to prepare the planning commission recommendation form for the city's signature with the stipulation that we change the language to prohibit 1 and 2.
I'll second.
All right, roll call.
Joshua Brainerd.
Aye.
Steve Griffiths.
Aye.
Patty Crowan.
Yes.
Miles Schlesinger.
Aye.
Marcy Baker.
Yes.
Lenny Nelson.
Yes.
All right, it passed, and you can prepare that, and we'll sign it and send it off to the city council. Perfect. Any old business?
We do not have any old business tonight.
Any new business?
We do not have any new business tonight.
None. And any training?
We do not have any training tonight.
Okay. Reports and comments for the good of the order? All right, well, we won't see each other again until next year. So everybody have a wonderful, healthy, happy holiday. Don't eat too much.
One day, can I eat too much?
One day you can eat a lot. Okay, we're adjourned. Thank you.
We did it. Whoa.
I thought we'd be here forever.
I did too.
I did too.